My lord, 11,000 appointments have been made before 11/8/2023. 11,000 appointments. And in all those appointment orders, there is no condition that it is subject to final decision. And I have examined the entire order sheet of this WP 595 of 23. There is no IR. I'm speaking with responsibility. I have examined each and every order sheet. There is no IR.
These petitions. Direction has already been issued by the Supreme Court.
Exactly.
The mischief that the state has now committed is trying to protect all those weird appointees despite the fact that they are not protected by the legislation. Be prospective.
I'll give you a fresh cause of action.
But we had already come in and this court has already said that whatever Supreme Court says follow, they are not doing it. That's why we are here.
This is not a contempt petition.
It's not a question.
My lord, this petition has been dismissed on 3/5/2023 and the matter has not been remanded by the Supreme Court. How it has reopened, it is beyond my comprehension. Because the Supreme Court did not reopen it, Lord. That judgment dated 18/12/2024 did not remand the matter. It said that there are some issues regarding the inter-se seniority.
We don't have time, it seems, to have a detailed this thing. Malad may just fix us at the top of the list next week. We'll put up our respective submissions. If my learned friend on the other side is able to convince, Malad, that would follow. If we are able to convince that Supreme Court judgment rules the roost and we have to be given the benefit, Malad, so be it.
The Supreme Court has clarified on the basis of an application submitted
by state of Madhya Pradesh itself.
State of
Get there and got clarification.
Supreme Court.
Yes.
They have to give the appointments to us.
Only two petitioners. This is not a PIL. We are not arguing a PIL. Only two petitioners are there. Only two, not more.
We'll demonstrate that.
We'll take care of that.
We'll demonstrate whether 2 or 4.
But the starting point is to be, Lord, how this petition, how this.
Of all the persons holding vacancy was subject to the final outcome of the petition.
No, this is fact. This wrong statement. Please don't make this wrong statement. There is no such order.
Is there an appointment order on record?
Yes. My appointment order is there on record.
You have to see the final order 8/4/24.
Yes,
And it is an absolute appointment order and there is no IR. My learned friend might not have read each and every order sheet. I have read. No. Facts I never make incorrect. I am always prepared, Lord. I am prepared to write, demonstrate in 2 minutes. My learned friend is wrong on that point, Lord. There is absolutely no IR. Firstly, the petition is not even revived. Wrongly, High Court Registry has revived it, Lord. Petition is dismissed on 3/5/23. It is not revived.
What are anxieties, my lord? Not to, my lord, sort of leave loose ends so that the state seeks to exploit it and again throw us, my lord, in a long
again, Lord,
throw us again for the same thing.
We have to demonstrate 2 things.
If I may for a moment, Your Lordship, clarify. This clarification by the Honorable Supreme Court had come during the pendency of the petitions. This clarification by the Honorable Supreme Court had come during the pendency. We have already complied. That action has already been taken. The clarification came during pendency of the petitions. The petitions were disposed of on the basis of the clarification. That has already been examined. This has already been examined.
No, it's not written in my appointment order. Lord, this is wrong, Lord. Should not make. First you examine the record and then address.
1 second, Mr.
You
Shankar.
have examined each and every dot.
What the Supreme Court has said
Factually incorrect.
that this judgment will be prospective. Prospective operation shall be only for those candidates who were appointed without any qualification.
Yes.
So their appointment letter has to have a qualification.
Yes.
Or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case. If somebody is before court,
Yes.
and there is such an order,
Yes.
or in his appointment letter,
Yes.
or even in the advertisement,
Yes.
saying that all appointments will be subject to.
Yes.
That's the only 3 conditions.
That we will demonstrate from the record.
That's the only 3 conditions.
That is the only thing.
That is something which the government has to look at and implement.
The government has determined not to look at that.
They have to do it.
No, in fact,
We-
in fact,
Mr.
your lordship, for a moment.
Mr. Sharma and Mr. Agarwal, we can't examine each individual's case. Is their responsibility? We can only say that Supreme Court has said qualification acquired prior to this date, those people will continue provided this condition is not satisfied. That is of an embargo. Post that, all go.
If for a moment, your lordship, I may submit.
Mr. Mr. Sharma, please tell us one thing. How do we examine how many people are there?
11,000 have been
How,
appointed.
are we going to examine all 11,000 then?
He demonstrates the first advertisement से पहले ही High Court का rider है वो मैं आपको
All right.
वो हाई कोर्ट की पिटीशन डिसमिस हो गई है, withdraw हो गई है.
Your lordship,
withdraw हो गई है.
for a moment, if I may be permitted to,
और notifications पे लिखा हुआ है, sir, appointment order.
if I may be.
इसमें नहीं लिखा है तो सारी
We are not saying they submit what they have to say. Because what they say, they are giving it, they interpret the order of the Supreme Court differently.
And against which they went to the Supreme Court again. Twice the matter has traveled to the Supreme Court. Once when a clarification was sought during the pendency of these petitions before this honorable court.
Lord, I'll tell
So
you.
it
Lord,
requires some
what
hearing,
is
your
this
lordship, it
second
must.
Mr. Rupna,
After the-
is this condition not applicable on the government?
No, it is applicable. We
That
have
if
already
somebody is
implemented.
appointed
We have,
Before that cutoff date with a rider,
we have implemented and acted as per the orders passed by the Honorable High Court and Supreme Court. Your lordship, may kindly for a moment. If I may be permitted to make my submissions for a moment, your lordship
how
may,
many taken out, not taken out?
My lord.
if
My
I,
lord, one thing, I would only want to say one thing, Lord, which is the starting point of this, my lord's exercise of jurisdiction. 3/5/2003, this petition is dismissed. Now the matter goes to the Supreme Court. Supreme Court does not grant any interference. What the Supreme Court says, let me complete myself. What the Supreme Court says, that there is a dispute between inter se seniority of the B.Ed appointees and the D.El.Ed appointees. For that, some petitions are pending. Let that dispute be. That is the dispute. Lord, we will read that document and accept. We'll
Mr.
read the
Rupra, the
document
position is
18/12/24.
Mr. Rupra, the position is this. Supreme Court has said that B.Ed degree not valid after 11th August 2023. Simply sit a B.Ed degree not valid.
My lord is reading which order, Lord? 18/12/24? Because that is how my lord has got the jurisdiction to hear the matter.
8/4/2024.
18/12/24.
subsequent, there is a
That is
subsequent
harassment.
order, there is a subsequent order of the Honorable Supreme Court.
18/12/24 is the clinching point. 18/12/24.
On the basis of which they are
On the
claiming
basis of
that
which, my lord, we are hearing